Everyone. A very warm welcome to all the panelists and the participants joining us today for the webinar on succession planning. I'm Pratichi Avinash, Marketing Manager at R&M India. I would request everyone for an active participation throughout the webinar. If you have any questions while our speakers are speaking, feel free to share them in the Q&A box below. All questions will be taken up in the end of the session. It would be appreciated if everyone keeps their phones on silent mode. I hope this session will be worthwhile for all the attendees. I would now like to hand over to Mr. UN Marga, Chairman R&M India, for the welcome note.
Thank you, Pratiji.
Over to you.
Good afternoon, ladies and gentlemen. It is my privilege to welcome all to this much anticipated webinar on succession planning, an essential yet often overlooked aspect of sustaining legacies for generations to come. On behalf of R&M India, I extend gratitude to each one of you for taking the time to join us today. We are truly honored to have a diverse audience comprising industry professionals, business leaders, and aspiring change makers from across the globe. Planning your family's future and assets is crucial for harmony and a smooth transition to the next generation. Succession planning ensures your rights, assets, and legacy are protected, especially from non-traditional relationships like gay couples and live-in partners. This webinar will explore key strategies, legal framework, and the tools for estate planning, asset management, and succession, helping navigate these complexities with confidence. We are fortunate to have an esteemed panel of speakers who bring a wealth of knowledge and expertise to the table. Allow me to introduce them. Mr. Raj K. Lakhotia is a director of the Chessie Group and advisor at Dil Se Will. Raj has been negotiating complicated financial environment for more than 20 years and specializes in succession planning, tax advisory, and transaction advisory. He serves as a managing partner of Lab and Associates Chartered Accountants and a director of Chessie FinOps Private Limited, a management consulting catering to diverse industry verticals. These firms provide comprehensive support to SMEs from to incorporation to operational guidance. His clientele spans large corporations listed on the Indian market, SMEs and startups, and more. Additionally, he founded dilsewill.com, an online platform that offers services linked to succession planning and streamline the will making process. This project demonstrates his creative thinking and was supported by NASSCOM. The West Bengal government named him at one of the top 5 super startups. He also frequently contributes to Economic Time Wealth readers' will and succession related questions. Welcome, Raj. Kajal Aswani.
Thank you, sir.
Kajal Aswani is a family lawyer and a partner at Hugel and IP Hong Kong. Kajal specializes in dispute resolution with particular focus on family law and private client matters. As a founding member of the South Asian Lawyers Group in Hong Kong, she has been instrumental in creating a network platform for legal professionals and law students of South Asian origin, fostering their integration into Hong Kong's legal community. She is currently a member of the Women in Business Committee of the British Chamber of Commerce. Her past roles include serving on the executive committee of the Amber Foundation and as a committee member of the Young Solicitors Group of the Law Society of Hong Kong. Mr. Vikas Jain, he is the fund manager at R&M Capital FME LLP Gift City. He brings nearly a decade of experience in equity markets, primarily specializing in sell side equity research. Throughout his career, he has honed his expertise in identifying promising investment opportunities by conducting in depth market analysis and financial modeling. His focus has been on delivering actionable insights to institutional investors, including mutual funds and insurance companies, enabling them to make informed investment decisions. His ability to uncover value in equity markets and effectively communicate these opportunities has established him as a trusted advisor in the investment community. Madhvi Ahuja is a renowned author and founder of the Writers Web, a director at Bharat Bhushan Equity Traders Limited, a stockbroking firm. She has 13 years of experience in finance. Madhvi started business content writing under the name Writers Web in 2013, catering to business writing requirements on national and international platforms. Her passion for writing led her to pursue courses at the University of Oxford and at NYU in her 30s. She has ghostwritten autobiographies and anchored Cupidity, Ping Me Love, and now her latest product, the Legacy Journal, about which we shall be talking today as well. And guiding us through all these discussions will be our moderator, Raghu Marva, CEO of R&M India, whose expertise and insights are invaluable. A qualified chartered accountant, he joined the R&M team after gaining experience at the Big Four and has a wide experience of more than 20 years, specializing in advising and structuring businesses abroad for Indian corporates, building India entry strategies for foreign clients, cross border holdings, merger and acquisitions, and valuations. He oversees the consultancy services and international taxation of the firm. Raghu is passionate to growing the business and has successfully launched an asset management entity in Gift City under the name of R&M Capital FME IFSC LLP. I'm confident that today's webinar will be both engaging and enlightening. So, without further ado, let's get into the session and explore the path to successful succession planning. Thank you once again for being with all of us. Let the session commence now. Thank you.
Thank you so much, Mr. Marwa, for your words of encouragement. And good afternoon to everybody. I'm Raghu Marwa. And when we thought about a webinar, the first question that came to mind is what percentage of companies worldwide have a formal succession plan? And the answer that ChatGPT came up was only for 14%. This highlights why today's discussion is so important because we'll be discussing not only the corporate succession planning issues which are abound, but also the issues around personal or family succession. And without further ado, I'm going to jump in with the first speaker, Mr. Raj Lakhotia. Rajiv, has I know you've been in this space of online wills, and some would say that you tinkered into this space quite early on. Do you feel today the time has come for online wills and people doing setting up wills online themselves? What is your view on this? Over to you, Raj sir.
Thanks, Raghu, for asking this question. And before that, I'll thank Marwa sir for a wonderful introduction. It's really so nice to hear so much good thing about yourself, right? And thanks to all my co-panelists, Vikash, Kajal, and Madhvi, as well as Pratichi. Well, coming to your question, Raghu, online will execution has different steps. Drafting of will, signing by the witness, registration, and then the finally the execution of the will after the death of the person. So in India, right now, what we are doing is the drafting services is online. I started the services in 2016. At that time, NSDL has taken up this initiative. They have started the online will creation model through easywill.com, and we started simultaneously, I would say. Initially we found that it is really very difficult to make people understand that why you should make the will, and then why you should make it online, right? So I would say post covid the thought process has changed a lot. People have realized the importance of having succession plan in place. People have realized that if the will is not in place, or if any other mode of succession planning is not done, then how the family get impacted because of this not ability. Now, just to give you a figure, in 2016 the PIB has come out with a report which said 76% of cases in India is because of property and family disputes. Such a large number of cases which are pending before courts, and these are the cases which has traveled to the courts. There are cases which has settled outside the court जो कि हम account for ही नहीं कर रहे हैं. So then we realize that it's a good space to get into. In Western countries, the model was already in place. So we realized that sooner or later India will also be prepared themselves for it. Now, presently we are providing the drafting services online, but then post drafting all the services are offline still in India. Reason being the regulations in India are not allowing us to have a digital will in place. The digital signature is not acceptable so far as will is concerned. IT Act prohibits the digital signature. Then, succession laws and the evidence laws which are there in India do not permit the digital signature to be acceptable. Then there are issues relating to the authenticity. How will you establish the authenticity? How will you store the will so that it is not falls in the wrong hand? So all these things are there with the online will in India at present.
Wow, seems like we still have a while to go before an online digital will become a reality. But fingers crossed, I think India is a pioneer in a lot of digital initiatives. So hopefully, this will be one of them in the future. The next question, Raj sir, is about the legal position on rights of partners in a live-in relationship. India's society is rapidly changing. You have more and more young people, or even older generation people who are in live-in relationships. Are there any legal rights for such partners? Over to you.
So it's again a very I'll say very thought-provoking question, I would say. um, See, in India the succession rights comes from the succession law. And if I speak about Hindus, it is Hindu Succession Act which is in place. If it is a intestate succession, and if it is a testamentary succession, then Indian succession law will prevail. Now, unfortunately, there is nothing which has been given in these two acts so far as living couples are concerned. However, of late, Supreme Court has, said that living relationships are allowed, permitted, legitimate, and the children from the live-in relationships are also been given a legitimate rights, right? Now, there are two aspects to this. One is a right on the property of the partner and the right of the child out of live-in relationship. Some of the judgments has said that the couples have the right on each other's property. But by and large, succession law is very silent about this. Many judgments have said that the partners have maintenance right, not the right on the property of each other. However, so far as child is concerned, out of the live-in relationship, the child has are considered as legitimate child and has the right on the property of the parents. Now, the self-acquired property of the parents, child has the right. However, still there are litigation relating to the ancestral property of the parents, whether the child out of the live-in relationship has the right on the ancestral property of the parents. So this is presently the scenario so far as legal situations for the live-in relationship couple are concerned.
So two things, Raj sir, that I want if you could elaborate on. One, you use these technical terms testamentary and interstate. So for the audience, if you could break it down so that it becomes a little simpler for them to understand these technical terms. And the second follow-on question would be regarding, everybody's abroad. It's a very common phenomena to have a prenuptial agreement, right? Has that become more popular in your view in India since you deal with such issues around will and succession? And is that again legally enforceable? Any of these prenuptial arrangements are enforceable? Because, like you said, especially with live in, there could be issues around, okay, let's just sit and make a prenuptial so that we avoid any confusion later. So, over to you on both these aspects.
So coming to the first point, if a person dies without having will in place, and then the properties are distributed to the legal heirs as per the succession law, which is Hindu Succession Act. And when the succession law guides you how the property shall be distributed, it is intestate succession. However, if you make a will or some other mode of succession planning you have done, then it is called testamentary succession. Under that situation, the Indian Succession Act is applicable on the person, not the Hindu Succession Act. This is a difference between the Indian succession, between the intestate succession and the testamentary succession. Coming to the second point, yes, we keep getting inquiry relating to the prenuptial agreements, but we are not dealing in that. Legal position, I am not the right person because I am not a lawyer for that segment. But then again, it's more of till the time you get into the marriage, the situation is same, that is of the live-in relationship. So the legal position will be same for both the cases.
Wonderful. I mean, I think in terms of this whole issue that the government is talking about of, unification of family laws, where the Hindu Succession Act that you just talked about, the Indian Succession Act, and, obviously there is a separate law for the Muslims in India. I'm assuming that when the new law comes in, or if the new law comes in, all of this will merge into a single kind of a platform. What are your views on that?
I really hope so. And we are actually waiting for a complete overhauling in the succession laws in India. Just to touch upon one simple aspect, if I have to say that father is not considered as a class one legal heir for a Hindu. So you can understand that how old this law is, and time and again presentations were made to the parliament to amend the law, but then nothing has happened so far. So I am really hopeful that the new law which is coming in, which we are talking about, should be able to address all these issues.
That's awesome. So you've left us with some positivity for the future. And at this point, I want to quote from the Bhagavad Gita, which said that persons realizes peace who relinquishing all desires exist without craving and is unidentified by the mortal ego and its sense of mindness. I think when it comes to succession, everybody talks about, mindness and mera tera. So I think it's a good point to shift gears, and we're going to go next to Kajal. And
Just
sorry.
I want to make one point here that the Bhagavad Gita is also the outcome of succession issues.
Yes, absolutely. Well pointed out, and that's why I thought of quoting from it, because if such a marathon war, epic war could be fought merely on succession, that goes to represent how deeply ingrained it is in our society. And I think we should all learn from that and get more and more clarity in our succession planning. So with that, I'm going to move to Kajal. Hi, Kajal, again.
Yes, hi. Thank you, Raghav, and all my panelists for having me speak on this very exciting panel. And thank you, Mr. Marwa, for the kind introduction earlier, and Pratichi for a wonderful job in having us all together this beautiful afternoon. I think I just want to add a bit of additional background about myself. So I've said to a few of you earlier, I was born and raised in Hong Kong, and I've been practicing law now for over 18 years. I speak the local language of Hong Kong, which is Cantonese, and of course I can speak Hindi and Sindhi because I'm Indian by origin. Now, over the past 10 to 15 years, I have seen a huge growth of an Indian community in Hong Kong, particularly with expat Indians moving to Hong Kong. And I think this is probably attributed to the fact of Hong Kong having a very low tax regime, Hong Kong obviously being Asia's international financial hub, as well as the Hong Kong's recent government's drive to attract talent. So what is happening and what I'm seeing is most families moving to Hong Kong from India are professionals with children. And as a result of that, I've seen an increased number of inquiries on succession planning from Indian families in Hong Kong. And now, for the audience wondering, why is a Hong Kong lawyer sitting on this panel? I think that answers your question. It's because I'm always having to work with Indian lawyers. And my clients will have questions relating to Hong Kong assets as well as Indian assets. So in those situations, and when Raghav asked me to speak, and I was like, well, I think that, yes, we will be talking about the more topical issues on same-sex couples as well as gay marriage rights in Hong Kong. But I also think that, the most prevalent thing that's asked by me, by Indian community in Hong Kong is like, Kajal, we've got an asset in India. How do we deal with it? How do you deal with it? So I always tell my clients, it's always desirable to have one will, which can deal with all of your assets and to deal with probate in one jurisdiction. But from experience, I also feel that if you have assets in India and if you have assets in Hong Kong, it's best to do two separate wills. We call it multiple wills. It's based on jurisdiction. So, and I think there are multiple benefits as a result of that. I think the probate fees can be lower. You can have assets, for instance, in India under your will being dealt with the Indian lawyers. There can be local languages. Your wills can be drafted in Hindi in India. You can comply with the local rules. I understand in India, correct me if I'm wrong, because I'm speaking to some of your experts here, but wills are registered with the High Court, whereas in Hong Kong, we don't have such registration system. And I also think that if you have two wills, your probate can be in parallel, your administration process can be dealt with in parallel. That just minimizes the cost as well as the anxiety that comes with gathering all of the assets. Now, where I have clients who are domiciled in India and have assets in Hong Kong, we also have dealt with quite a number of clients and simplified the process, because then what it entails in us doing is a simple application at the probate registry once you have a grant in India, and then we can then make the application here to deal with the process. So it's relatively straightforward. And yes, so yes, I do have to come across Indian lawyers from time to time in dealing with these issues. Yeah.
Thanks so much, Kajal, for that. And as a follow-up question, again, just keeping the audience in mind, A, can you break down what a probate is and what the probate process is? A lot of people may not understand the probate process. And secondly, in terms of your recommendation for two wills, one for the Hong Kong asset and one for the Indian asset, could that also lead to greater litigation if the legatees choose to, do jurisdiction shopping, right? In terms of, one legatee is based out of India and they want to pursue only in India the case, and somebody's outside. So does it complicate matters? So over to you on this question, then we'll move on. Yeah.
So maybe I'll start with the latter question. Now, if you have two wills, as I said, the multiple wills will not overlap. They will deal precisely with assets in those jurisdictions. So, I think the only thing that you would have to ensure to avoid any disputes is that there would be no overlapping in terms of the beneficiaries. So if you have assets that your beneficiaries are to bequeath in India, then you keep that separate. And if you have beneficiaries to bequeath assets in Hong Kong, you keep that separate. So in that aspect, I would say that, make sure that there's no overlapping provision, because then, or inconsistent provision rather, because then what would happen is, yes, that you might have some conflicting issues there, right? Now, with regards to your first question, probate, well, what that means is if you have a will, then you basically have to have that dealt with through a probate registry. It's an official registry in Hong Kong, where you then would demonstrate that your will is valid. And then there are procedures in place once the will is considered valid, that you get this grant issued. And on the will, you would have this person called the executor, who then has the authority inferred or given to him by way of the will, to be able to then gather in those assets. And those assets then will be distributed to the beneficiaries as per the terms of the will. So that's simply the process of probate.
Perfect. And just, so that the audience understands, this advice for two different wills, I think it would be equally valid if it was, in UAE or in other places, right? If there is an international and there is an Indian, have the international bucket exclusively done separately and the Indian bucket. Yeah, that makes a lot of sense. Absolutely.
Yeah. I mean, to be honest, okay, so like, for instance, if I have clients in Singapore with assets in Singapore, I understand there's a process in Hong Kong called resealing. So what happens is you can get a grant, or like the UK, for instance, I've done a case with UK jurisdiction. If you have a Hong Kong will, you get a grant in Hong Kong, then all you need to do is take that grant, go to the UK and get that grant resealed. Then you don't have to go through the whole fresh process of probate, where you have to basically establish that the will is valid, who the executors are, etc. You don't have to do that. India doesn't have that resealing process with Hong Kong. But as I said, for that reason, I would advise my clients do two separate wills, keep things simple, have the processes ongoing in parallel, have then your, if you're domiciled in India, but you have assets in Hong Kong, we can help with these simple processes in place to be able to gather in your Hong Kong assets once you've obtained your Indian grants.
Perfect. Thank you so much. I think there's a great takeaway from that. Next question, Kajal, is rights for gay couples and live-in relationship status in Hong Kong. We heard Raj talk about, the multifarious litigation in India around live-in. But
yes.
Are things clearer and simpler in Hong Kong where you are at?
Well, unfortunately not. Now, it's a very exciting space for Hong Kong right now as we speak, because there has been major developments. And I'll first talk about these same-sex couples. And I think it's important for me to put some context by giving you some background on the Hong Kong's cultural issues. And as you all know, that Hong Kong used to be colonized by Britain for many years. So therefore, Hong Kong is influenced by both Eastern and Western traditions. So before the British colonization, the Chinese customs were prevalent, and which include the concept of concubines, so like a mistress, and they accepted the concept of polygamous relationships. Now, once the British came, that changed the whole concept, and they basically introduced Christian marriages. And in Christian marriages, there's this concept of, a marriage is only valid if it's a marriage between one man and one woman, right? So that was a concept, right? And now this concept has been enshrined in our marriage ordinance. So as a result of all of that, same-sex marriages in Hong Kong are not recognized, okay? But then came the Bill of Rights in 1990s, which introduced the concept of equality. So what that meant, and since then, what we've seen several challenges by same-sex couples against the government to try to recognize these fundamental rights on the principle of right to equality, right to respect private life or family life. And as a result of that, there was one of the most recent decisions handed down by the top courts of Hong Kong called the Court of Final Appeal as recently as November 2024. So it was just a couple of months ago. Basically making changes to recognize the rights of same-sex couples. When I say the rights, I will talk about what these rights are. But as of now, while speaking to you, same-sex marriages in Hong Kong are not recognized. Okay? So what does that mean? What does that mean? If it's not recognized, what does it mean for same-sex couples in Hong Kong? So if you are married, let's say in the US or countries which recognize same-sex couples, and then you move to Hong Kong, what happens? So in the context of marriage, if you're deciding to divorce, Hong Kong will not give you a divorce. You can't divorce in Hong Kong because same-sex marriages are not recognized here. Now, that said, again, because there have been major challenges by the LGBTQ community in Hong Kong, there was a decision by the Court of Final Appeal in 2023 where they considered the constitutionality of the laws of Hong Kong relating to same-sex couple as discriminatory and demeaning. So what the Hong Kong government did back then, sorry, not the Hong Kong government, the courts did then in 2023, direct the Hong Kong government to give them 2 years to come up with an alternative legal framework to recognize same-sex partnerships. Now that 2 year is going to expire in September 2025 this year. So while speaking to you right now, nothing of that sort has happened. We all are waiting in eagerness to see what the government of Hong Kong is going to do. But as of now, there is nothing. And because we're talking about succession planning, I think it's important for me just to touch upon some of the developments that's happened in this area with regards to same-sex couples. So before 2024, if you were married overseas, a same-sex couple married overseas, came to Hong Kong, and if your spouse died, then the surviving spouse, unfortunately, would not be recognized as a surviving spouse in Hong Kong, and therefore they would not, and if your spouse died without a will, you would not be entitled to the estate. Now, since 2024, in November, that's changed. If you are married overseas as a same-sex couple and you come to Hong Kong, and if your spouse unfortunately passes away without a will, you will be recognized and you will be able to inherit under that regime. So that is in respect of inheritance. I have a couple of other points, but I feel that, for the interest of time, perhaps I just want to move on then to the next question on live-in couples and what their rights are in Hong Kong. So with regards to live-in couples, so unlike the US and Australia, the live-in couples do not have the same legal status comparable as marriages. Okay, so if you are cohabiting with a partner, you don't have the same rights in the event that the marriage breaks down or in the event of death. So again, talking about inheritance, what happens in those situations? If you're living together as a couple, but you're not married and your spouse passes away, or your partner rather passes away, do you have any entitlement? The answer is no, but we have ordinances in place, and this particular ordinance is called the Inheritance Provision for Family and Dependents Ordinance. Now, what that does, that if your partner supported you financially, and if you were able to demonstrate that there was financial support that you were receiving from your partner, then you can make an application for a financial provision from the estate. But those financial provision will be awarded only on a needs basis. Okay. And this is very different from if you were married, because if you were married, Hong Kong compared to India has very generous laws. The starting position for Hong Kong in the event of divorce is 50-50 division of assets. So it is quite unfair, but we don't recognize de facto couples. And as a result of that, I would suggest in situations like that, consider having your wills in place, consider having prenuptial agreements if you are planning to get married, or even cohabitation agreements, so at least your rights are protected.
Super. I think this is very exciting, and all of what you said is seems as if there are lots of wheels in motion and things are really changing very rapidly. So thank you so much for that, Kajal. And this reminds me of something that Dwight Eisenhower had said, that plans are nothing and planning is everything.
Yes.
So with that, I'm going to switch gears to Vikas, who's our next speaker. Hi, Vikas.
Hi. Hi, everyone.
So, Vikas, my question to you is, how can long-term investing in the equity asset class contribute to succession planning? And here, obviously, we're talking about an individual or a family who wants to pass on a legacy to the next generation. Is an equity asset class something worthwhile to pass on? And how can somebody who wants to do that from a long-term point of view go about doing that? Over to you, Vikas.
Sure. First of all, thank you so much for inviting me to this webinar. I believe the topic that we are discussing right now is from a has gained a very solid prominence these days, and more so has gained even further importance as businesses in India have continued to reach new scales, right? So I'd like to divide my answer into two viewpoints. Firstly, from a business viewpoint or a corporate viewpoint, and secondly, from an investing viewpoint, as you just mentioned, right? So coming first to from a business viewpoint, right? So while some large scale companies, and here I mean large scale MNCs or like IT companies and banks and others, they are typically run by some professional managements, and they do focus a lot in terms of have devising a proper strategies in place as far as the succession planning is concerned. They have separate teams which look after grooming the individuals either from within or identifying people from the similar industry to ensure that there is a smooth succession planning as and when there is a leadership change that is either set to happen or in case of any exigencies. They do have all those plannings and procedures in place. However, one important point that I believe in some of the companies where some first generation promoter companies which have done a lot of work in terms of establishing the business, starting the business, putting their all life, energy, money into their business. In such companies which have grown scale in India have generally seen to be lacking these succession planning initiatives. And this is where I believe a lot of family tussles and issues actually come out into the picture, right? So one important reason for this is clearly no demarcation of authorities or responsibilities by the first gen promoter clearly being demarcated either to the second gen, which is their heirs coming into the business, and this is where the actual issue starts out, right? Uh, and then a classic example that comes to my mind is of the Reliance Group of Industries, right? A clear absence of business segregation by Mr. Dhirubhai Ambani when he was alive, I believe, created a lot of family issues and feud that is known to all, and that entire issue even went to courts, but was eventually settled by Mrs. Dhirubhai Ambani. And yes, but the only point I would like to mention here is that had there been a proper demarcation or a drafting of or a segregation of authorities, probably some of the group companies that have suffered because of these issues would have had a different fate altogether. Second classic example that I recall, and which is even ongoing as of now, is from a famous company named Godfrey Phillips. It is the second largest cigarette company manufacturer of India. I guess people would have heard of the brand Marlboro, which is a very famous name of cigarette brand, having almost around 15% market share in the company or in the country, right? So this company is also currently ongoing the same issues where the first generation promoter, that is Mr. K.K. Modi, after his death in 2019, his vast holdings became a big point of dispute, and the dispute is none other than between the mother and her two sons, right? And the case is being well fought at the court, and even as on date also is being fought at the court, in the court proceedings, right? So I believe that while these two examples do give some insights, but there are a lot of family tussles which do remain and are more importantly are detrimental to the overall business, which has been started with a lot of struggle by the first generation promoters. So the only point I'd like to mention here is that while these companies, while India is doing a fantastic job in terms of scaling the businesses, which was not something that has been seen in the past. But yes, with with this kind of growth being seen in such companies, I believe devising a proper succession planning even becomes utmost important in this space. Second point I'd like to mention is from the investment standpoint. This is where I would like to draw the focus on, where while many strategic investors or I'll talk of venture capitalists or mutual fund, and they also consider this succession planning angle to be a very strategic one, and believe me, this is something where even most of the investment decisions are also being taken on, or rather I would say, if there is an absence of any succession planning, however good the company be, there are chances that it can go off the table, right? So this has gained a very significant prominence these days. Just taking back that same example of Godfrey Phillips, right? The stock, while the company has been doing really very well, however, because of this family tussle, there has been no mutual fund participation into this company, or it is a very minimal participation, only and only because of this. And hence, I believe this clearly shows that there has been a very significant importance given by the investors to this point, and hence, again, repeating the same thing, it needs to be given significant importance from across businesses.
Thank you
Yeah.
so much, Vikas, for that. And yeah, I think it's well understood that succession is no longer something on the fringe. It is very much center of when it comes to investing, and from an investor perspective, that is something that they should consider. With that, I'm going to switch gears and move to our next speaker, which is Madhvi. Hi, Madhvi.
Hi, Raghu.
Thank you
you
for
for
your
having me.
patience.
No, thank you for having me. Thank you, Mr. Marwa, for your lovely introduction. I agree. It's so wonderful to hear things about yourself. It feels good, great. And thank you, Pratati, for organizing this lovely webinar for all of us.
Thanks. So, Madhvi, my first question is, there was a recent interview by a stalwart in his 90s, where he talked about the autumn of his life. So, since you have gotten into the legacy journal, which we'll dive in a bit, but how important do you feel it is for a individual to really plan for the autumn of their life, right? Because there is life expectancy which is growing. It's more and more that people in their 90s are around to bless not only their grandchildren but also their great grandchildren. So, how important is it, in your view, for an individual or a family to plan for their elders to in the autumn of their life? And is it okay that suppose you had a granddad who has a new girlfriend tomorrow? What is your view on this, Madhvi?
Yeah, let's not DLF our lives right now. Um, I definitely, that's a great question, by the way. I definitely think it is very important. Yes, longevity has changed. I think if you look back, 60 was a benchmark and 65, and now you are looking at people, uh, ripe in health also at like 95, 98. And yes, there has been no or very little planning done around it. Um, the fact of the matter is that as you grow older, the capacity to work is going to diminish. Your productivity in your 30s is not going to be the same in your 40s, nor is it going to be in the 50s. And that will keep changing. A lot of people like to retire, a lot of people like to work till the end of time for them. And for that very reason, whether you're working or you're not working, you must have a certain quality of life that you have catered to all your life and built towards living. So when you are at that autumn where you are supposed to be enjoying the best time, and hopefully in good health, you must have enough saved, enough invested that you're not worried about living a less life than you're used to living. And I think to be able to do that, and Vikas, thank you for your words. But to be able to do that, I feel people like Vikas are important because it's a long-term game that you're playing, and it's a consistent game that you're playing, and it has to be sustainably done so that you can actually make the rest of the entirety of your life a comfortable space for yourself. And I think that would be a great achievement if all of us started in that context, saving in our 20s, so that by the time we are in the ripe age of 85, we're able to afford exactly how we envision life to be.
Yeah, I think, what made that interview, for me at least personally, very contentious was the fact when he said that, I've given away 95% of the ownership of the listed company, given away, the chairman position and whatever, rights and privileges comes with that, and to my kids, and whatever assets I had to give, I've already given it during my lifetime. I mean, I think that can be a little disconcerting to some who want to hold on to that power till the end. What's your view on that?
So I think Raj would have witnessed this more than I have. But the fact of the matter is that I think in the Indian context, inheritance holds you hostage in that way. And I don't think everybody can think like this, that let me, in my lifetime, already give everything, set everybody up, have my own life. I think that's a very modern way of thinking, and great that people are thinking like that. But I think by and large, it is that if you have an inheritance, if you don't behave like this, if you don't produce like this, or if you don't, you know, create the life that I am imagining for you, I'm done. No inheritance for you. So I think it's a concept change that has to come in. It's a very healthy change. I think it's talking about what you have with your family should be a very transparent topic. It should not be something that's left for only after you're gone that they get a sense of what you have or what you don't have, or not even like what's mine or what's yours, just the sense of what that is as a family. I think there should be transparency in that, and people don't like doing that because of the fear that if I do give in, then I've lost all control.
So at that point, let me invite Senior Mr. Marwa. Why don't you share your views since you're the eldest on this panel as to what Madhvi just said? I think it's a interesting topic. I want to, just get everybody's view on this. So over to you, Mr. Marwa.
You see, needless to be said, succession planning is most essential for the longevity of the businesses, for whatever somebody has one generation has worked for the next generation to move it up the ladder and at the same time enjoy the hard work of the previous generation. It's most necessary. And the smoother that transition happens in business, you have to hand over. You're running a relay, you reach the end of it, hand over the baton and move on. Right? Now let somebody else do the running. Yet at the same time, as you grow older, the feelings of insecurity are bound to be coming in. So fair enough. Secure yourself. Let the elder generation who's worked for it secure themselves monetarily, which need not be in terms of power. At the end of the day, you need money. So you have a mix of whatever your stocks and your liquids and whatever, and hand over the baton to the rest. Okay, now you guys move. This is my security for me and my wife till they are there. And thereafter, ideally have a family settlement. Is the best method if it's possible. Will, of course, as they all said, is there. But if you can have a family settlement, makes life easier. So there's no issues likely to arise then. And that's my advice to everyone. I think it's most essential now for businesses to continue and grow, right? To have some kind of succession plan discussed openly, forum with the kid children, which there was in our generation or earlier generation, a hesitancy to talk. One always felt, you can't talk these things. But yes, for the sake of the family and the business and the longevity, one needs to. And that's the only way to move forward.
Yes, perfect. Thanks so much for that. So Madhvi, I think you heard the older generation saying, give it in your lifetime, keep what you want to secure yourself, but at least give clarity so that business and things can go forward. So with that context in mind, A, what is a legacy journal? And B, is a legacy journal complementary to a will? Is it complementary to what, like a family settlement, what Senior Mr. Marwa just said? What is this whole concept?
So the legacy journal basically came out of a conversation with my family concern, which is Bharatbhushan and Company, where we're investment advisors. And it was a conversation that happened that said, what is it that is required in a family in terms of information without it being overly intrusive or overly spilling more than you really need to. And so, on the basis of that, this journal has been created. It is a precursor to a will for sure. In my view, it is a journal that should be in every household that has an income, because what this does is it's a it's a one physical format that you have that gives you all the information required. For example, Mr. Marwa and you are in the same family, right? You probably know the ins and outs, but there are still certain things that he might assume but you technically would not. For example, the advisors that he's dealing with currently, they could have changed over time, be it a legal advisor, be it a financial advisor that he's speaking with. So what this legacy journal does is, without it being intrusive as to what's going on between you guys as conversation, is just penning down exactly who are the people concerned in your life for the particular areas that are important. So we created the legacy journal with 6 parts. We started with personal information. We go into what your IDs are, what your what your Aadhars, all your personal IDs, any banking information, in terms of, this is my account, this is the account number, this is the person concerned, and this is the the location of the bank. Because these are the kind of information that, even though if you're living in the same household, you probably don't have at all times with each other, right? So it's a single person's book of all the information that matters kept in your locker, kept in your safe. So it's not something that you're going to fill out right now and hand over saying, here, keep it with you. You will keep it in a safe place that is accessible to your family when required. The next segment that we have in that is your investment information. So we're not going into what your portfolio is. It basically goes into who are the people you're dealing with, who's your advisor in that space, who's your broker, who's the contact person there, what is your your KYC in that information that's required. Things like if you have FDs and bonds, what are the details of those? If you have any kind of other asset classes like art and jewelry, their certification, the certificate numbers, etc. So that is the information that goes in, followed by your insurances. So it goes into your policy details, just the validity of the policy. It goes into your business interests. You might be a director somewhere, or you might be a shareholder in a company. You might be a silent partner somewhere. Who's the contact person in that company in case something happens to you and your family needs to connect with them. Loans and advances is also a section that we created because we're like, you might have given a loan to someone. You just want to put it down somewhere and keep a record of it. You might have taken a loan from someone that nobody knows about, and you were like, oh, I must have this down so that it's clearly spelt out for the family. And the last section we have is wills, trusts, and gifts. In that, again, it's not intrusive. I'm not telling you're not putting down exactly what else is in your will. You're just writing, my will is ready. This is the person concerned. Maybe the executor of the will's name is there. Are you part of any trust? Are you part of any power of attorney? Have you taken or given your power of attorney to somebody? So the legacy journal is basically a handbook for that. And I do have, I mean, I will hold it up so that you guys get an answer of what exactly is the legacy journal. I don't know if you can see it, but it's actually a physical book. It doesn't have a digital format at all because we don't want to go into the whole online space of what's going to happen if my information is taken away from me. I also think that in the current times that we live in, and a lot of and even me personally, it's not just a generation thing. I like to keep things in writing. I don't necessarily have to have it all on only a digital platform. I feel there's a little bit of a safety in the analog world. How long it lasts, I don't know, but it's there right now. So that's basically the crux of the journal. Like I said, to me, it's a book that belongs in every household that has an income.
Wonderful. Congratulations to you for putting up the whole legacy journal and creating awareness around it. I think Mr. Marwa has a question. I saw his finger up. You'll have to unmute.
I want the panelists to consider that, particularly in India, will becoming disputed is a common factor. And unfortunately, the judiciary takes a lifetime to give its final decisions. So half a generation can just go through in that litigation without enjoying the assets which the elders have left for. So don't you panelists think that a trust is a better format, right, rather than a will, whereby the person who's giving the assets sits in control as long as he lives or as long as he wants, which can be structured in the format of the trust itself. Yet the beneficiary is being defined, everything else is defined, and in his own lifetime, legally, he's given the asset away, and he's only a trustee thereafter. The beneficiary is being totally defined, which will reduce the element of risk and litigation that is in India. At the slightest opportunity, it can go to courts, and the courts will take 20 years or 30 years before a decisions come forth.
So, Raj sir, would you like to take this?
Yeah, sure. It's a wonderful point, Marwa sir, and I totally agree with you that trust is a better structure than the will, because will is highly prone to litigation, and we are seeing a lot of litigations going on in the country on this will itself. However, the objective of having trust in place and only having will in place are different. So, if you do not want to keep a control, you just simply want to distribute all the assets post the demise of the person, then trust would create a lot of regulatory issues so far as assets are concerned. Most of the cases that we have seen in India relating to will that was subject matter of challenge is because of disproportionate distribution of assets, or a right of somebody, some legal heir, or someone who otherwise is a rightful entitlement of the assets are not protected. You need a good lawyer or someone who understands the subject to write such kind of will is nothing but it's a wish of the deceased person, and it should be self explanatory. It should be speaking document, as if in front of the court when we go for the probate proceeding, the person is standing in front of the court and dictating his terms. Court do not interfere, as in you do not want to give to X and you want to give everything to Y, but court just want to understand whether this is a valid point which you have included in your will willingly. That is what the matter of concern. So if somebody writes a will in a proper manner, giving all the surrounding circumstances, reason behind not giving something to someone or giving in a disproportionate manner, the litigation will go away. But in spite of that, trust is always a better structure to go with.
Thanks, Raj sir. I'm going to go to the Q&A and request Kajal for the first question, which is, if the will is registered, how imperative is succession certificate in case of an immovable property? Kajal, would you like to take that from a Hong Kong perspective?
Sorry, I'm just going to read the question. So in Hong Kong, as I said, we don't have registration of wills. So the obligation would therefore be that you would have to demonstrate to the probate registry that the will was valid, properly executed, and then all of the requirements of the will are satisfactory. So for instance, the will was not witnessed by beneficiaries, there was no coercion, the testator who did the will understood the contents of the will, etc. So it's once you have been able to satisfy those requirements and the registry is satisfied that you are the executor, then the grant of probate could be granted. And then once the grant is provided to you, you as the executor can then go in with that grant and start gathering in the assets for distribution to the beneficiaries.
Super. Raj, so we're going to go to the next question, which is addressed to you. It's a kind of a long question. I'm going to read it out. If in a will where husband gives residential property to his wife, can he put a clause that even after probate of his will, as wife gets the property, she will not be allowed to sell this property or offer it as an asset for any party to borrowing against this asset? So this asset will always be free of charge by any party. So for the residential property that's made by the husband as their post-retirement house, the wife will use it till she is alive. Wife can write her own will, also give the property to party she wishes to give to. By doing this, husband will protect his wife from coming under any pressure from any third party to sell the house or to generate cash also. Is this sort of a thing possible as per Indian law?
So there are two type of possibility. One is absolute bequest, and the other one is creating life interest. What is absolute bequest is you have given a property to someone as a beneficiary. Once the assets is transferred, you do not have any control on those assets. Subsequently, what he or she is going to do with that property, you do not have any control. The second is you create a life interest on the property so that he or she can enjoy the property throughout his lifetime, but he or she cannot sell it. The property in that case will pass on to the subsequent beneficiary or whoever is in the line, but the person who is right now the beneficiary doesn't have the ownership right on the property. He has the right to enjoy the property. So but once you do the absolute bequest, then you cannot have a control, then you cannot guide the person that after your death, or you cannot do, you cannot sell the property, you cannot mortgage the property, or you cannot do anything with this property. Once the absolute bequest is done, the property belongs to him. That's it.
Thank you. We'll take the last question. Unfortunately, I think Kajal has a boat ride to catch. So, Kajal, this next question is for you. If the property is jointly held and the first holder is deceased, is it imperative to amend the conveyance deed before selling the property, or does the second holder transfer the property to the kins or sale?
So if the property is jointly held in Hong Kong, we have this concept called sole survivorship. So if it's a joint property, the other party will become the sole survivor and the owner of the property. In terms of the logistics, I mean, in Hong Kong, we will then register the grant at the land registry to demonstrate that the sole survivor is now the legal and the sole beneficial owner of the asset, to avoid any requisitions being made by purchasers who are wishing to buy the property. So, we will have to then deal with the land registry and place some registrations there. But insofar as the conveyance deed is concerned, like I said, in Hong Kong, the concept of sole survivorship exists with joint properties. So I believe the answer is no, there wouldn't be a need to amend the conveyance as a result of that, because we will then be registering this document with the land registry.
Thank you so much, ladies and gentlemen, for your kind participation and attention. Thank you again to the panelists for wading through all of this. And in the end, I just want to leave you with one word, which is succession is not about leaving a legacy. It's about creating a future. So please consider that and look forward to your active participation in future webinars. Thank you.